I gave you different cases stating a reasonable time, but they were diverse. They were not the same. They were not the same. So the German Bundesgerichtshof, the German highest court, decided recently that 1 month after delivery, let's say minimum, that this was certainly always a reasonable time. And I think this is a good approach by saying that a minimum of 1 month, well, that could be required, but no less than that to have to be able to say it's a reasonable time. And the Swiss court in another country, in Switzerland, not in Germany, so they are not bound by what the Bundesgerichtshof said, but they followed the lead and they said, yes, that's a good compromise. 1 month after delivery, that's a minimum. And we have then another case, the Spanish case there. It was about the sale of flags. It was for a world championship, I think, of football. They made, they ordered many flags to sell to the fans of the club, and the flags were not conforming to the agreement, and the notice was sent 2 months after delivery. 2 months. Okay, said the court, that's fine. And I think that's a good decision indeed. 2 months, that's still reasonable. Don't require that this notice is sent earlier than 2 months, than 1 month before, than 1 month after delivery. Now, having said that, we have another question, which is, when does this short period begins to run? And the answer is there, and I have 2 cases which I cite in the syllabus. First case is a case where a pony is a small horse, a pony is sold, and when it's delivered, the buyer sees, well, after a few days, sees that obviously there was a pre-existing injury, which made that the pony was limping. Obviously, it was not an injury which had be suffered after the delivery, but it was already before the delivery, pre-existing. And so the buyer warned without the protesting, but he said, well, something is wrong. He warned the seller, and they kept in contact, and he told further days, well, the situation is worsening, and only when after a certain time the veterinary doctor saw that he gave a final diagnosis of the injury. At that moment, the buyer sent a notice of non-conformity, and so it was later than at the moment when he discovered it. He discovered the injury after the delivery. Didn't react immediately. He gave it a chance, but kept in contact with the seller. And then at a certain moment when it was clear that it was non-conforming, then he sent a notice saying, well, sorry, but this is the problem. The goods are not, the horse is not conforming to what was agreed, and I'm very sorry, but I will have to avoid the sales contracts. In another case, it was a Spanish court who said, well, it's not necessary, it's not sufficient that the buyer suspects that something is wrong. Well, the goods arrive, and at inspection, at the examination, something seems, it's a machine which was delivered, something seems not very optimal, not very good. But it was still not sure that it was not functioning, the machine, because she had not been operational yet. She had not worked really operational. And the court said, well, while the buyer waited till the machine could get in operation and work, then he saw that really it didn't work. Then he was certain. So that's the starting point of the reasonable period. It's not the day or the moment when the buyer suspects that the goods are not conforming, but it's the day where he's certain that the goods are not conforming. That about this reasonable period, but there is a second requirement. The notice which the buyer has to send according to Article 39, Article 39, first alinea. The notice which he has to send must not only be in time, it must also be sufficiently precise. So describe exactly what's wrong. What is the defect? What's the nature of the defect? What's wrong? Why do you say, buyer, why do you say that the delivery is not conforming? You must precise do it. And here again, of course, some courts are very strict. And if you are just a little German course, and there is something correct in that. In this sense, the buyer must be a bit precise. He must say, but the court may not be exaggerated, but the buyer must say exactly what's wrong, but without going perhaps too much details. But at least the seller must understand when he gets the notice what's the problem, because then he can take steps to cure the defect, or he can take the necessary steps, but therefore he must know what's wrong. So the notice must be sufficiently precise. We saw yesterday, and then I start with the lesson of today. We saw yesterday also that the buyer, if he doesn't do that, send a notice in time and precise enough. If he doesn't do that, he loses his right to the possible remedies. You know that the buyer can eventually require specific performance, or require avoidance, or require damages to be paid. Well, he can't get any remedy if he didn't notice, send a notice in time and precise, sufficiently precise, which is a very strong rule. Buyers must be very careful to do it, because the consequences are very serious. Now I come exactly to what my subject is for the moment. It is the latent defects. So what is a latent defect? You know it already. It is a non-discoverable defect, non-discoverable by a decent, reasonable inspection. That's Article 38. You can't discover it. The goods are delivered, but you can't see it. It's there, the defect is there, but it's not visible, or at least detectable. Even well, a careful examination doesn't see that something is wrong. Only later on, perhaps months later, the defect appears. The machine doesn't work, but what happened? And then one discovers, oh, but it's due to a defect which existed already at the moment of the, at the delivery. In fact, earlier, eventually, at the moment of the passing of the risks. And then the buyer must give a notice, according to Article 39.1. At that moment, dus after the discovery, he gives a notice. Or at the moment, if he doesn't discover it, but he is negligent, he didn't care. And but normally he should have discovered. If he had been a person, a reasonable person, he would have discovered the defect earlier. Perhaps not at the because it's not visible, not at the moment of delivery, but at 2 months later, he should have discovered it. Or he waited for 5 months before he sent the notice. That's too late, of course. And then we come to the question which I met already. What's the consequence of the failure of the buyer to give a notice of the latent defect? Well, here too, he loses his remedies. It's the same as for the discoverable defects. Even if the defect was not discoverable, if at the moment when he discovers it, he doesn't react in a timely way, in a reasonable time, he loses his remedies, and he cannot rely on them. So it's, as I said, a very sad situation. But well, I give you, but there is one exception, as you know, even two. There are even two exceptions. One is the seller knew of the defect, or he should know. If he had been full of attention, if he had been a careful seller, he should have known. And I gave you yesterday an example, which is a very good example and very well known. The example, remember, of an American buyer who sold a machine to a Chinese buyer, and the machine, it was a press to produce rails, frame rails for trucks, and the press didn't work, function well. That's what the buyer saw when the machine was delivered, and the Chinese buyer sent a notice, well, telephoned or faxed or emailed to the seller, and they say, well, you need a substitute part. There's obviously a defective part, and the seller sent that part, the defective part, but without instructions. There are no instructions, and there is no supervision. They don't send an engineer to China to see what's wrong. So the poor Chinese buyer has to do it himself, and it doesn't work. And obviously, the seller knew but didn't disclose that something was wrong. And the buyer discovered finally what exactly was the reason for the non-functioning of the machine, and he sent a notice, but only 3 years, in God's name, 3 years later. So normally you should think, oh, well, no, this is the poor buyer lost all his remedies. But in this case, the court thought and the court is right that in view of the facts, in view of what happened, the seller should have known, even if he didn't know, perhaps he knew, but even if he didn't know, he should have known that something was wrong, that the goods, that the machine was not conforming to what was agreed. And that was the case. So the Chinese buyer, although it was very late when he sent a notice of non-conformity, 3 years, it was an arbitral court in Stockholm. Stockholm is very well known. The International Chamber of Commerce of Stockholm is very well known. They have a special arbitral tribunal, and well, that tribunal thought that the Chinese plaintiff was right. Another more recent example is a French example, where an Italian manufacturer sold to a French buyer tile coverings. So it's for the roof of a house, tiles on the roof of a house. But later on, it was proved that this roof, these tile coverings for the roof, was unfit for the use. It had to cover the house, not let water coming inside. It was unfit for the use, and this was due to an insufficient enameling coating. You see, these tiles which were put on the roof had to be coated, painted with enamel. Enamel, it's like your teeth. This is an enamel. Well, this kind of painting on the tiles was insufficient. So that was the reason why the tiles were not conforming to what was agreed. But the seller who had discovered there had been unfavorable tests and trials even before the delivery. And so he, of course, knew it, or he should have known it. He should have known it. And then the buyer gave notice, but much later. It was nearly like in that Chinese case. Here it was not 3 years, but 2 years. 2 years after the delivery, notice was given of non-conformity. Article 40 was applied. The seller knew of the defect, and so he can't rely on the fact that the buyer had not given a notice in time. I must stress here that the courts must be careful, must be extremely reluctant to accept this excuse. There must be a clear evidence, and in those 2 cases, evidence was clear indeed, clear evidence that the seller knew or should have known, which is the same. About this latent defects, an important rule now. That's Article 39(2), second alinea. 39, second alinea, 2. That's about what we call the cut-off rule. Cut-off. The rule is that if no notice is given in a period of 2 years, 2 years after delivery, 2 years after delivery, buyer who didn't give notice loses his right to rely on the lack of conformity. And that's not only the notice, which is too late, but it could be also, and that's the case for, because we are speaking about the latent defects, the indiscoverable defect, it could be that, but that's rare, but it could be that a defect only appears after 2 years. Well, if the defect appears after 2 years, of course, the buyer can't give notice before the end of 2 years, because the 2 years already 2 years from the delivery on are already passed. So it's too late. So if he gives notice after 2 years, perhaps because he didn't discover it before, perhaps it was because he was just too late. He discovered it before, but he was too late in sending the notice. But also it's possible that he discovered it only after 2 years. Well, in the two cases, there's nothing to do. 2 years, that's a cut-off period. It's if there is no reaction of the buyer in 2 years, it is too late. Now, don't mix up here this notion of cut-off with the notion of the period of limitation. Period of limitation. You know that notion, you saw that in Chinese law, when you have a contract, after the claim of the plaintiff, well, after some years, his claims are prescribed. You can't sue anymore in court. So the time to bring the case before the court, to start an action in court, to start the procedure in court, the time can be finished. You can't go before the court anymore. Well, that's what is called in the English law. Well, that's a term, the limitation period. And limitation periods, ladies and gentlemen, is not in case of sale of goods, is not regulated by the Vienna Convention. The Vienna Convention doesn't speak about the limitation period. So this cut-off rule of which I spoke, that's not a limitation period. Limitation period means here that the buyer or the seller, for what reason whatsoever, cannot bring a case anymore before the court. And that's not defined in the Vienna Convention. But there is an international convention on the limitation period. That's a convention of 1974. Only 30 states ratified that convention. But during the negotiation of the Vienna Convention in 1980, they thought, well, we have to amend, to modify eventually the International Convention of 74 on the limitation, to accord it, to accord it with the Vienna Convention, in order that there shouldn't be a contradiction between something which is said in the Vienna Convention and this convention on the limitation. And that was done. So for the countries which ratified the International Convention on the limitation period, this limitation period is 4 years. So 4 years after delivery, 4 years. If you start an action in justice after 4 years, it's too late. The judge will say, well, sorry, your action is prescribed. The limitation period was reached. A last point in this context is, what about a period of guarantee, a warranty period? Okay. So that's something which you often find in sales contract. The seller, who wants to be a nice guy, he wants that everyone to think, oh well, that's a good, that's a nice seller. He will give a guarantee. He will guarantee a certain period in which the goods will stay well functioning, well conforming to the agreement. A guarantee, that's a clause in which the seller guarantees the conformities of the good during the period mentioned in the clause. For instance, a clause saying, well, I guarantee that this machine is working, I give it for 3 years. Guarantee. If something is wrong, automatically I'll replace the machine. Yeah? Or 18 months. Or so. But there you have a problem of interpretation. What does that exactly mean? Well, the text, the text of the clause of guarantee, the warranty clause, does not prevail above the 2 years cut-off period. We met Article 39, we met that the rule that is a cut-off of 2 years. Well, eventually the interpretation can be yes, but this clause doesn't prevail. This 2 years cut-off period continues to exist. But the reverse is true too. If the parties want to, but it must be clear. So when you interpret the contract, it's clear that that's what the clause meant. Then the clause can prevail above this 2 years cut-off period. Is that clear? I'll have a little short chart to show you again what we said. You see that?
Hi, Professor. I think that the picture need to be closer to the camera.
Like this?
Yes, it is clear now.
Okay. So you see here, there is, well, here you have the passing of the risk. The defect must exist. Then you have the examination, a reasonable time after delivery. That's the delivery, a reasonable time after that. There must be examination. If a defect is discovered in that, by this examination, a notice must be sent to the seller. If the examination doesn't discover a defect, but later on it will be discovered, so the defect appears here, you have a reasonable time here in which the notice must be sent to the seller. So you see in green, that's the time which is, let me see it, because in green, that's the time in which the examination must be done, and then in red, that's the time in which the examination must be done. In green, that's the time in which the notice must be sent. And here, when you have the discovery of the defect, you have the time here, and there, that's the notice. So there's a notice for visible defects. Here is a notice for indiscoverable defects. And then here in red, there's a period of 2 years. There's a period of 2 years from the delivery. See the delivery, 2 years. And when this period is finished, after 2 years, you can't. It's too late to send a notice. It's also too late if you discover a a defect. But you still can, for some reason, if there are other reasons, you can still sue before court. But that is not possible anymore. That's 2 more years here to arrive at 4 years of the limitation period. Here it's too late to sue in court. Is that? I think that should be very clear. But of course, I'll put it a bit further so that you can have a general overview. Right?
Yes.
You could do it.
Clear.
Is that? It's clear, Monsieur?
Yes, yes.
Now, another problem, but still in the chapter on the conformity. Conformity is not only a question of the goods are not functioning as they should. It's not only the goods are not conforming to the agreement, not the quality, not the quantity. It's also, there's another problem. The goods which are sold and delivered, it is possible that someone else, a third party, someone else, pretends to have a right on that good. And so the buyer is annoyed because what happens, there's another person and the seller who is coming to say, well, for instance, I am the owner of that thing. How come that you have it? I'm the owner and I can prove it. So ownership can be a claim by someone, but not necessarily ownership. It can be also another right in rem. For instance, a creditor of the seller who had a security interest in a good, and the seller sells the good. So the creditor follows the goods and say, well, that's what he says to the buyer. Well, I have a security interest. I have for instance, this was a pledge, or think of the idea of an hypothec. Do you know what an hypothec is? Normally it's on a house or an apartment. A creditor has an hypothec. That means if it's a right in rem, it's not the security is not just binding the party who, for instance, who lent money and gave the apartment as a security. It's not only him that's bound, but everyone who becomes later on owner of the hypothetical good. What says also, well, that's the English term mortgage, a mortgaged good. Everyone who becomes owner must repay the loan, because this security interest is a right in rem. You know, I imagine this distinction in the civil law between rights in rem and rights in personam. You know that distinction? Rights in rem and rights in persona. For instance, a typical right in rem, well, the right in rem par excellence, that's the right of ownership. But also, for instance, the right of the given by a pledge or a mortgage. They are security rights, but they are rights in rem. Well, a claim of someone who has a right in rem on the goods which are sold, that means that the goods are not conforming, that the goods, well, that means that the seller will be liable. So that's a first hypothesis of a claim by a third person. There will be a second one. I'll come to that in just a moment. That will be claims based on intellectual rights. And that's not a right in rem, but an intellectual right. But I'll come to that in a moment. First, the claims based on a right in rem. For instance, I said someone pretends that he is the owner of the goods. For instance, a car is sold, but the seller didn't know that this car was stolen. He bought it from someone, didn't know that it was stolen, and then he sells it. And that's here the litigation is between that seller and the buyer, because what happens is you have the seller and the buyer, but when the sale is concluded and the car is delivered, after that, the third party, who then is the third party who's the real owner, they stole the car from him, will sue the buyer. And the buyer said, what's that? I bought the car, I paid it, and now you annoy me. That's the hypothesis here of the claim of a third party. So the rule is in the Vienna Convention that the seller must deliver goods which are free of third-party claims. And the first hypothesis of three-party claims, that's a party of a third party who claims that he has a right in rem. It's enough that there is a claim, the mere assertion of a third party that he is the owner, for instance, or that he has a security interest in the goods is sufficient. Of course, it's not the assertion of the seller himself. Because we saw yesterday, we remembered yesterday that the seller, when he sells the good, can insert in a contract a clause of reservation of ownership, a clause of retention of title. When there is a retention of title, that means that the owner who sold it but keeps the ownership till a certain moment. For instance, till the moment that the price is paid, and then the buyer will become full owner. But that's not what is meant here. So if there is a problem about this clause of reservation and the seller sues his buyer because he doesn't respect that clause of reservation of ownership, of retention of title, that's not what's meant here by a claim of goods free of a third party claim, because the seller is not a third party. The seller is not a third party, of course. If the claim of the third party is frivolous, it's just invented, or it's not serious, it's frivolous, then of course it will be not accepted eventually by the court. But the buyer is not entitled to avoid the contract normally, except if he has some damages due to this, then he could obtain some damages, but the sale will not be avoided. When you, and we have an interesting question here, when you have this problem that a third party claims that not the buyer, but he has a right on the good which the buyer bought, and it comes before the court. So the third party really sues the buyer, it comes before the court. The third, for instance, the third party says, I am the owner of, I have a right of interest. This is the loan. This is a sum that the seller had to pay me as a security for that loan. He gave me a security interest in the goods, and now he sold it. Well, I'm sorry, but I'm suing you. You are not the you have not a good which is free of my right. So I want to, from the court, that the court says that you have to respect my right, my security interest, and if it's really for his pay what the seller had to pay me. Now the question is, the interesting question is, can the buyer who is annoyed say to his seller, I'm annoyed by someone who is suing me in court. Come here, come and help me. Help me in court. Gives me some, stand at my side before the judge. Stand at my side in court during the legal action. Is that possible? So as does the buyer, on basis of this article saying that the seller must deliver a good which is free of a third-party claim, can, on basis of that article, the buyer say, seller, you must help me. Come and help me in the court action. Can that? Well, I will answer that tomorrow, because we need therefore a comment of Article 28, and that's I explain that tomorrow. But I can already say you now that if the domestic law applicable according to the private international law is a common law, the answer is no, because that wouldn't be possible in the common law. Let me say a last word about this. That is that the if there is a problem, if the third party has a problem, the third party has a problem because he had a right, could have a right of ownership, but this right is cut off because he's in good faith. Due to the fact that the seller sold the goods on which his right was based, the seller, who is in good faith, became the owner. There's nothing to do anymore. He became the owner. Well, then the third party, what do he do? Well, the only thing he can do is suing the seller, but that's another problem. It's not in the contract of sale between seller and buyer. The third party can perhaps sue, but that's another problem that has nothing to do with the law of sale. And so that's something you saw in civil law. That depends from the domestic law applicable according to the private international law. That's a question of which is outside the scope of the Vienna Convention. And then you have the, but perhaps I don't know if I have still time. Michel, do I still have time to finish that first hour?
I think it is about 1 hour.
Yeah, well then let's stop here a moment then, 5 minutes, and then I'll continue in this in 5 minutes. Good?
Okay.
Good. See you. Have a nice. Good. We just saw, ladies and gentlemen, that the seller has to deliver goods which are free of the third-party claims. And we saw that these third-party claims can first of all be rights in rem. Secondly, that's the point we are reaching now, this right of a third party can be an intellectual right. So not a right in rem, but an intellectual right. Just to put it in the frame of the convention, let me read Article 41. Article 41 says, the seller must deliver goods which are free from any right or claim of a third party, unless the buyer agree to take the goods subject to that right or claim. However, if such right or claim is based on industrial property or other intellectual right or other intellectual property, the seller's obligation is governed not by this Article 41, but by Article 42. And now Article 42 is the article which I now will explain. So the hypothesis is that the claim of the third party who is annoying the poor buyer, that claim is based on industrial or intellectual property. You know what this term means, I imagine. You learned that in your law courses, but it's a patent, it's based on a patent of the invention of an inventor, or a copyright, that's also an intellectual right, or, and that's what I will take as an example, but it's very concrete, very practical, a trademark, a trademark. What is a trademark? Well, a trademark is a type of intellectual property consisting of a recognizable sign or a recognizable design which identifies a product. It identifies a product of a particular source from products of other manufacturers. So the trademark owner may pursue legal action against trademark infringement. Most countries, and that's also the case for China. In China, there is a trademark law of 2001. Well, in most countries, like in China, the trademark must be registered. There must be a registration of the trademark. Because otherwise you can't, the trademark owner can't pursue can't sue the infringer, the people who is infringing his trademark. I give you some examples. Well, you see, that's a nice shoe, but you have still better, you have still chicer shoes. For instance, the shoes of Monsieur Libotin. These are shoes which are very expensive because it's just a trademark, you know. They have red soles. The sole of the shoe is red. That's typical for the Louboutin. For instance, and it's very expensive. For instance, Melania Trump, the wife of the ex-president of America, Melania Trump, she was always wearing this kind of shoes. So you see, very chic. Now, if some manufacturer of shoes imitates those shoes and tries to sell them as if they were Louboutin shoes, that would be an infringement of the trademark of Monsieur Louboutin. You see? And that happens. We had a famous, I think now 2 years ago, a famous case before the European Court, precisely by Monsieur Louboutin, who was suing someone, a copycat, who was copying his way of presenting shoes, and he won his case. You see, other examples are, for instance, also in shoes, shoelaces. That the case which came before the French Cour de Cassation. You had a shoe, but the laces of the shoe were a special form, and there was a trademark on it, and so the owner of the trademark sued the user of this. Well, the buyer who bought these shoes, he sued him, but of course the buyer of the shoe, it's not his fault. He bought those shoes. He sued. That's what interests us. What the buyer who is sued? No, the buyer who is annoyed. Yeah, he can be sued, of course, by the owner of the trademark. The buyer will return and he will sue his seller and say, what happens? Look what happens. There's a third person who pretends that he is the owner of the trademark who is suing me. Or another example, just to make you well understand what a trademark is, you know, perhaps the raincoats, Burberry raincoats. They are. It's not just a raincoat, but the tissue of the raincoat is special designed. You recognize immediately. Oh yes, of course, that's a Burberry. And so this trademark is protected. Well, at least if it is registered in a country. Good. Well, that's what Article 42 says. Now, very important, we saw that the fact that the seller didn't know that the goods were not conforming is irrelevant. If the seller knew it or didn't know it, no problem, he committed a breach. It's sufficient that the good is not conforming. So the knowledge of the seller, the fact that the goods are not conforming, is irrelevant. But that is not true here. That's not true here for the intellectual rights. So I attract your attention to the fact that Article 42 on that point is different from Article 41. 42 is different from 41. What do I mean by that? Well, if it's important in the case of industrial property, in the case of a third party claiming that he has an industrial property right on the goods sold, if the seller didn't know of the existence of the intellectual right of that third party, that can be relevant. In other words, in certain occasions where he knew it, the seller knew it, didn't know it, he can say, well, I'm not liable. The seller didn't know it, it's not liable. And when is that? Well, you have two cases where he didn't know it, and where the result will be that he is not liable. That's 42. He knew or couldn't have been aware of the possible claim. The trademark, for instance, was registered in a special in a certain country, and he proves, but he has to prove it, that he didn't know or couldn't have known that. But it's more than that. There's a second point. He couldn't know because it is possible that it was registered and existing in a country where the goods were he sold, and which he, as a seller, couldn't know that that was the final destination of the goods. So his liability is limited to the infringements in some countries, namely one, country of the place of business of the seller, of the buyer, country of place of business of the buyer. For instance, a Belgian sells goods to China. Well, is the place of business of the Chinese buyers China, but in China the trademark was registered, or the country of destination, because the Chinese buyer exported himself. There was a resale to another country, for instance, to India, or to Vietnam, or to Japan, and the seller knew of this destination, But in that case, the seller is well, at least if he didn't know it, is not liable. So the knowledge, in other words, the knowledge of the seller is important in those cases. So I repeat that, that's Article 42. You must read it, and you must be careful by reading it, and keep your attention, because it's not easy to grasp immediately what the article means. Article 42(1). I'll leave it to you. You read it quietly when you are at your desk. But is that clear? Let me perhaps say it again. So we are speaking of claims of third parties based on an intellectual right. But in those cases, the knowledge of the seller that such an intellectual right exists is possible. That knowledge is important, because if he can prove that he didn't know it, or of course that's important, or didn't have to know it, he couldn't, he didn't owe, he didn't owe to know it. Well, he didn't know that there was such an intellectual right owned by the third party, and he didn't know that, or together he didn't know that in the country in question where this right was infringed according to the third party, he didn't know that the goods were this country as destination, or well, it was not the country where you had where the buyer has his place of business. I read you the article, so you, well, I perhaps should read the article. Then you read 42(1). The seller must deliver goods which are free of any right or claim of a third party based on industrial property or other intellectual property, of which at the time of the conclusion of the contract the seller knew or could not have been unaware, provided that the right or the claim is based on industrial property or other intellectual rights. A, under the law of the state where the goods will be resold or otherwise used, if it was contemplated by the parties at the time of the conclusion of the contract that the goods would be resold or otherwise used in that state. Or B, in any other case under the law of the state where the buyer has his place of business. See? Good. What now about the buyer who knew of the existence of such a trademark, for instance? The buyer knew it. The goods were sold, Burberry coats, for instance, well, an imitation of Burberry coats, and in fact, the buyer knew that it was an imitation. Yeah? Or in the Louboutin, in the case of the Louboutin shoes, you know, well, no, this is not the Louboutin shoes. Here are the Louboutin shoes. In the case of the Louboutin shoes, here, the buyer knew that he bought imitations. He knew it very well. But in that case, of course, the seller will not be liable. The knowledge of the buyer will exonerate the seller. The buyer who becomes aware that a third party has a claim must send notice in a reasonable time to his seller. And for instance, in a case of a stolen car, the Bundesgerichtshof, the highest court, Supreme Court in Germany, said that a notice 2 months after the car seizure by the police is too late. So a car was sold, and obviously it was a stolen car. The seller didn't know, that is of no importance. He didn't know, but a third party who was the real owner obviously went to the police, and the police discovered that it was a stolen car, seized the car, and 2 months only, well, already 2 months after the seizure by the police, finally the buyer said, well, I'm suing, well, I'm not suing him, but I'm sending a notice to my seller. You sold me a car which is not conforming to what we agreed, because there is a chap here who pretends that he is the owner. Well, that's too late. 2 months is too late. Further question here. What happens then if it's too late? What's the consequence of the failure to notify? You know it already, of course. The buyer, who is too late, loses all its remedies. But, and here is again an important point, Article 43, 2, second alinéa. In the case that the seller knew of this intellectual right, for instance, of this trademark, the seller knew it, that will preclude him from relying on the failure of bringing a notice. That's something we met already. Yeah? We met already that if you are too late as buyer to send a notice, the result is you lose your remedies, except if the seller knew it, that we know already. But here you have the same, but with a difference. There is a variation, and you find that in Article 43, 2, second alinéa. Because that article, and that's a difference between Article 43, 2 and Article 40, if the buyer proves that the seller could not have been unaware of the fact that a third party had an intellectual right. It was registered, it was okay, he had a trademark, for instance. You should have known it. Even if you prove that you in fact didn't know it, but you should have done. Is that sufficient? For Article 40, it is sufficient. Here not. It's only if he knew. If he knew. That's the difference between Article 43, 2 and 40. Then there's a last point, and that's Article 44, the excuse. The buyer can have an excuse why he didn't send a timely notice, an excuse. That's in Article 44. Legislative history. How come? Where does it come from? Well, during the negotiation, the developing countries, African countries, for instance, found that the consequence of the failure to notify, these consequences are too severe, too extreme, too drastic. You lose all your remedies. No, that's going too far. And so Article 44 was accepted. But the case law now in our days is this is not restricted to developing countries. The courts apply for all traders, for all buyers, even in very well developed countries, even in Japan, even in China, even in America, can invoke Article 44. But it is of course of narrow interpretation. The buyer, for instance, of a stolen car in my example, cannot say, well, I have an excuse for my late notice. The court will say, well, no, after even a layman understands that if the police sees a car, that something will be wrong. This, to accept that there is an excuse, the courts are very, very, very reluctant. But it can happen. One thought of it for developing countries because, for instance, one thought of this example in, and I know this very well because I stayed for many years in Africa. You know, it could be that a factory is paralyzed because the central electricity power plant doesn't function. There's a defect during a certain time, no electricity. That's what happens now for the moment in Texas. In Texas, due to the extreme winter weather, there's a problem, and during a certain time, the electricity plants in Texas didn't work. But normally you don't have that in Texas. But it's very common in African countries. And so, if, for instance, machines are delivered, but you can't start the machine because there's no electricity, but you can't see, you can't discover that the machine is not conforming, because to see that the machine must be in progress, must be working, and you can't see it if there's no electricity. That's of what they thought when in the legislative history of Article 44. But now I'll give you an example of a good example where the court accepted indeed, and it was a correct decision, that there was an excuse. And the example is this: you know that goods must be inspected, examined when they are delivered to the buyer. Now, sometimes this inspection is entrusted to an independent body, an independent third inspector. It could be even a state body, a government body. So if the inspection happens too late by this independent inspector, of course, the notice, which if they discover a defect, if they discover that the goods are not conforming, of course, the buyer will be too late by sending a notice because he knows it only when the inspection is done. Well, that would be a good excuse, you see. And then the result of it is that the buyer loses indeed. There's nothing to do about that. He loses his right to require specific performance or to require avoidance, yes, but he retains the right to obtain damages. So that's at least that. He has an excuse, he can at least obtain, if it's accepted, obtain damages, or also restitution, well, not restitution, but reduction in price. The price is diminished, reduction in price. Voilà. That for the non-conforming goods and for the goods which are not free of a third-party claim. And then we come to lesson 8. Lesson 8. That's about the obligations of the buyer. Up till now, we spoke of the obligations of the seller. The seller has to deliver, and the seller has to deliver conforming goods, which are also not, which are freed of third-party claims. That's the obligation of the seller. But what are the obligations of the buyer? Well, the buyer has the obligation to take delivery and to pay the price. First, obligation to take delivery. Sometimes in international trade, it's the buyer who arranges for carriage by sea, for instance. He cares for it. He appoints the carrier and he pays for it. Of course, the carrier has to take, well, the goods must be taken over by the carrier, and so the buyer has to warn the seller, inform the seller of the place of departure of the carrier of the carriage and the time of the shipment. He must say to the seller, well, I'm sitting in Brussels. I buy the goods, but I buy the goods, but the goods who are in Holland, and the goods will be the ship, which or the train or the truck will where the seller can load the goods will be at that place and at that moment. It can also be that in most cases in international trade, it's like that. It's the seller who has to arrange for the carriage and who pays for it too. And we saw that when we spoke of delivery. Well, in that case, the buyer must, of course, designate the place of destination. He must tell to the seller, well, you of course, I know that you will care for the carriage, but you have to bring them at that place in Shanghai, destination Shanghai. Article 60b says two things about the taking of delivery. First, the buyer must make the necessary steps in order that the seller can deliver to the carrier physically. That's, well, 60b speaks about the obligation to take over the goods. But first of that, Article 54 says that he must take also the necessary steps to make it possible for the seller to deliver. And an example of a necessary step, the buyer must inform the seller of the place of destination where the goods must arrive. If the seller doesn't know it, if the buyer is too late in communicating this information, well, that's a breach of the duty to take delivery, as Article 60b asks. Not exactly, he is not breaching the obligation of taking delivery, but the obligation of taking the necessary steps. I take Article 54, take it. And you must do that too. You must look up each time I mention an article, you must look it up. Here, 54, the buyer's obligation to pay the price includes taking such steps as may be required under the contract to enable payment of the price. But that's also, this article is also applies also for the obligation not only to pay the price, but also of the obligation to take delivery of the sold goods. 54, 54. But 60b has especially the object of speaking about the taking delivery. 60b. Buyer's obligation to take delivery consists in taking over the goods. So taking delivery, this is something very physical. It means taking over the goods. When? What's the moment? What's the time of taking over the goods? Well, it can be either a definite date, the 22nd of February, or it can be any day in a certain period, from the 1st till the 20th of February. Sometimes in international trade, one doesn't know exactly when the ship will arrive. One doesn't know a few weeks before when will the ship exactly arrive. It depends from a lot of circumstances. And so what does it say? That's the date of arriving, and that's the date when the buyer must take delivery. But there's a certain period in which the ship can arrive, and in that period, when the goods are put at the disposal of the buyer, he has to take delivery. If he fails to take over, for instance, in a sail with carriage overseas, the ship arrives at the point of destination, the buyer must take over the goods, must take physically possession of the goods. If he fails to do that, he doesn't show up, or he refuses. Well, that's a breach of contract. That's a breach of contract, and he will be liable for possible damages. For instance, if he doesn't take over the goods in time, and in the meantime there is a loss for the carrier, because you know, in carriage of goods, if it's all very strict in time, if a ship stays longer than the time which is provided for, he has to pay. So the ship has to pay, and of course he will ask it to the person who shipped the goods, and that one will of course turn to the buyer who is negligent and who didn't take over the goods. So damages has to be paid. That's for the taking over. That's not a difficult notion. Then the payment. It is necessary to pay on the date which is, or the time which is contractually foreseen. It's not necessary, like it is in some countries, for instance in France, for instance in Belgian law, where it is necessary that the creditor, that the seller in this case, request payment. There must be a formal request to pay. It's called une mise en demeure. That's not necessary. Under the Vienna Convention, it's not necessary. He will, the buyer has to pay because it's set on the contract, and you see that date, say, oh, we are that date, yeah, I have to pay today. It's not necessary that he receives a formal request. Secondly, we saw already that eventually he has to make steps necessary prior to the payment, like the buyer had to do eventually steps prior to taking delivery. Also, he must make steps prior to enable payment, Article 54. For instance, typical example, it can be that he has to open a letter of credit. that he has to open a letter of credit. In the contract, it is convened that the buyer will open a letter of credit. We met that already. I can again show you that, perhaps. Remember, we saw it in this chart. The buyer here, I'll give you the chart again in a few minutes, but the buyer, no, here, the buyer has a bank, and the bank makes, sends a letter of intent. That's a negotiable instrument. It's not just an email. No. It's a negotiable instrument. He sends to the bank of the seller a negotiable, it's called a letter of credit. That's a negotiable instrument. That means that it can be transferred to someone else. And the one who holds the letter, he can exercise the right mentioned in the letter. So he says, I open a letter. What does that mean, in fact? Well, that means that this bank says to the other bank, I promise, I guarantee the payment of the sum which is mentioned in the contract of sale, the payment. If when I receive the bill of lading proving that the goods which are sold, that the sold goods are on their way to the buyer, so the bill of lading is sent by the bank of the seller to the bank of the buyer. Receiving the bill of lading, that bank knows, oh, the goods are arriving, or didn't already arrive. No, I'll pay. So I sent a few days ago, or a week or two ago, a letter of payment, a letter of credit to my colleague in another bank, and eventually a bank in the country of the seller. I send them a letter of credit, and now I receive from that bank the bill of lading. That's now the moment I have to pay, and I pay. I must pay at that moment, and I pay. You understand what a letter of credit is? I'll show you that in a moment back. So the letter of credit is, in fact, not regulated by the Vienna Convention. There is the regulation of a letter of credit. You don't find it in the Vienna Convention, but it is regulated by the International Chamber of Commerce. There's a special text called the usances and practices of the letters of intent. It's a special text which regulates the letter of intent. It was drafted by the ICC, the International Chamber of Commerce. That's why you know what a letter of intent is, and but you understand now what it means. Huh? Oh yeah, if this preparatory steps, opening a letter of credit, is not fulfilled, it's not done. So it was said that he would do it, but he doesn't do it, the buyer. Well, that's already a breach. Huh? That's a breach of contract, which eventually enables the seller to avoid the contract of sale. Aha, if it's like that, if it starts like that already, he doesn't open a letter of credit as he promised. No, I stop it. I ask for the avoidance of a contract. At least, because we'll see that for avoidance you need a fundamental breach. If this neglect of opening a letter of credit if it's considered as in that case, as a fundamental breach. Perhaps just 1 day too late, courts would say, well, that's not a fundamental breach. Huh? But if it's not sure that it's a fundamental breach or not, you can always use the technique which we will explain tomorrow of the Nachtfrist. That means you say, oh, he didn't open yet the letter of credit. I send him immediately a letter saying, what happens? You have just 5 days to do it, because otherwise I consider it as a fundamental breach, and then it will be a fundamental breach. Now the place of payment, okay, but where does a payment has to happen? Article 57. Article 57, you have 3 possible places, says Article 57. Either the place which is indicated in the contract, or, which is also possible, it's not said with so many words in the contract, but that's the place where always in the past, in the regular contacts between seller and buyer, that's a place where every time the payment happened. That's where the buyer paid. They always did it like that, so they will do it this time also like that, without saying it in the contract. So that's the first point. Contract, or eventually the usage. Second place, in the seller's place of business. Place of business of a seller. Third possibility, it's the place where the goods or the documents, bill of lading, are handed over to the buyer. These are the places of payment. And this notion of place of payment can have importance. I'll give you 2 topics where it has importance. The first topic is if there is a restriction on the export of currency, the export, for instance, of Vietnamese, what was the currency in Vietnam? Well, of the Vietnamese currency, let me say it in general, that is forbidden. So there's a decision of the state authority in Vietnam, say, forbidden to export Vietnamese money. Well, if the seller can't pay because the authorities forbid the export of that currency, it's important to know if that place is the place where exactly where it was agreed that the seller would pay, because perhaps he had to pay in New York. That was agreed. So if the currency export in Vietnam is forbidden, that is of no importance. So it's important to know where exactly the agreed place of payment is. And another topic where it can be of importance, but it's a topic which is not of interest in this course, but that's the jurisdiction. Again, we meet that notion of jurisdiction. It can be important. For instance, a case that it was decided by the Court of Appeal of Quebec. Quebec is one of the states of Canada. You know, Canada is a federal state, and one of the states is Quebec. And what is typical for Quebec is the law of Quebec is not the English common law, but is rather based on French law, the law of Quebec. And it's interesting. It's a bit like China and Hong Kong. Hong Kong has common law, but mainland China has Chinese law is rather of continental type. Here too, well, okay, Quebec. And there was a sale between an American buyer and a Quebec seller. So the seller was in Quebec, the buyer in America. Now, where did the American have to pay? Where had he to pay? And the court, because that's a question of jurisdiction. Now, the question was, he didn't pay, and the claim of the seller was brought. He sued, and it was brought before what court? Well, he sued before a Canadian court, well, in Quebec. And the problem is, of course, the buyer will immediately, that's typical, he will say, this court has no jurisdiction. Does this court have no jurisdiction? That's a problem. Which court has jurisdiction? Well, of course, there must be a convention, international convention, between the two countries. That was the case here, and the convention said that the jurisdiction of the court depended from the place of performance of the contract, performances of the obligation which was in litigation. Now, to define this place of performance, where was it in this case which I explained to you? Was it in America or in Quebec? And to find out, the Canadian court, the court of Quebec, used to interpret that term of the International Convention of Jurisdiction, interpreted the term performance of the obligation of the defendant by using the Vienna Convention. So they said, we use the Vienna Convention. According to Article 57, a possibility is the the place where either the parties contractually agreed it was the place, or where by usage between them it was implicitly agreed, and that was the case here. So by it was always what the parties had done. It was, they had already relations, those parties, and always in the past the payment happened in Quebec. Now, that was obviously the place where, according to Article 57, the place of payment could be situated. And that's what the court did. So to interpret the notion, place of performance gives jurisdiction to that court, they used the Article 57 to say, well, place of performance, that's a place in this of payment, Article 57. But for instance, in another case, that was, and I just mentioned it for your information, in another case between European states, between an Italian seller and a German buyer, the question was also, the Italian sued before a German court. Did the German court have jurisdiction? And to answer that question, you need the Brussels Convention, Brussels I Convention, but that's only valid for European states. Brussels I Convention saying that the court has jurisdiction of the place of performance, like in our Canadian case. The place of performance says the Brussels Convention. Now, the European Court said in this context, in a decision of 2010, in a case called the Car Trim decision. Car Trim, that's the name of the party, of the plaintiff in that case. Car Trim decision, case of 2010. The court, European Court said, well, no, to interpret the Brussels Convention, Brussels I Convention, you need to interpret it in an autonomous way, without reference to the Vienna Convention, like the Canadian court had done. No reference. You don't explain that notion, place of performance, by reference to other texts. We European courts will say once and for always, that's our interpretation of that term, place of performance. But that's interesting just to know. Other problem concerning the payment, the currency of payment. Currency of payment. We had the place of payment, but now the currency of payment. In what kind of money? Will you pay in renminbi, or in dollars, or in euros, or in yens, Japanese yens? What's the currency of payment? And normally, of course, this will be defined in the contract. In the contract, it will be said that machine is sold for that price, and the price in, for instance, in euros. A German seller who sells a machine could be in euros. He could say, of course, no, I want to have it in dollars, United States dollars. Okay. Now, if the parties, that's always the same, if there's a gap, the parties didn't say it. But then, well, then some courts say, well, we will apply the domestic law pointed at, indicated by the private international law, and the domestic law will tell us what is the currency of payment on the contract. But some courts, they say, no, the currency of payment, that will depend from the place of payment. If the place, there you have again the importance of the notion which we just met, place of payment. Place of payment, what's the currency of that place? If, for instance, the price has to be paid in Germany, what's then the currency is euro. If the place of payment is Egypt, it's the Egyptian currency who will be the currency of payment. Or so it could be currency of the place of payment, or also some courts apply the currency of the seller's place of business. Where is the place of business of the seller? Where is it situated? Well, in that country, the currency of that country will be considered as the currency of payment. Now, come back to my chart, which I gave you already earlier. Because I want to say again something about the letter of credit. Some contract, I told you already, may require the buyer to arrange for issuance of a letter of credit. And there, the payment will then happen by a local bank of the buyer in exchange for documents. We find that in Article 58(2). I told you already that the Vienna Convention doesn't regulate the letter of credits, but you find it in the text of the ICC. Remember what I said a lesson ago about the letter about the bill of lading. So the seller delivers the goods to, let's say, the ship captain. He issues a bill of lading. That bill of lading will be sent by the seller to his bank. See here, the carrier delivers the document to the seller, who sends it to his bank. That bank had opened the credit with that bank, and now he sends the bill of lading he receives to that bank, and he's obliged now, receiving that, to pay. What he does, he pays. See, of course, when he paid, the bank of the buyer will send that bill of lading to the buyer, so that the buyer can take delivery from the captain of the ship. Is that clear? So you have two documents, the bill of lading, and the letter of intent. Still something. It could be that the payment, when the buyer pays, it could be made a condition for handing over the goods. So when the buyer wants to get the goods, you want to take physically possession of the goods, it can be that there is a condition. First, he must pay. And Article 50, well, Article 58(2) says it with so many words that it could be a condition of the payment. But Article 58(3) says that anyhow, the buyer must have the right to inspect the goods, to examine the goods before he pays. So the buyer who was to pay, I'll pay, but first I must see that the goods are in order, are conforming to the agreement. We saw already, but that's something different. We saw that the buyer has the duty, has the obligation to inspect the goods when they are delivered. But that's something else. That's what we said, speaking of the conformity of the goods. But now I say something else. 58 doesn't speak of obligations. No, it speaks of a right. The right, the buyer says, well, before I pay, I must be sure that the goods are in good condition, that the goods which are still on the ship or which will be delivered when I present my bill of lading, I must be sure that they are in a good condition, in a good shape. So I have the right to examine them. And the article says he has that right, except the article 58(3) formulates the exception, except if it is contrary to a clause in the contract. It could be, and you have clauses like that. For instance, the clause documents against cash. Documents against cash. So the parties agree. I'll give you the document to which entitles you to get delivery, but first cash. You don't get the document if you don't pay cash. Of course, then he has no time, no occasion, the buyer who has to pay cash to receive the document has no time, has no occasion, has no possibility to examine the goods, because it will be only possible for him to examine the goods when, with the bill of lading, he obtains physical delivery of the goods. When he is in the possession of the goods, only then he will be able to inspect the goods, to examine the goods. So it's not possible to pay cash and obtain documents only then. It's not possible, I mean, to examine the goods in that case. So it means it's contradictory. That clause is contradictory with the right that in theory the buyer has to examine the goods. And then I have a last point, but I mentioned it already earlier in one of the first lessons, the price. That's what has to be paid, the price. And we saw already, but that was in the beginning when we spoke of the formation of the sales contract, the price must be definite. And definite means either expressly formulated, so many renminbi for that machine, or implicitly for maize that must be that has been bought. We can implicitly deduce that what the price will be. Could be implicit. And if it is not definite, what then? If it's not definite either expressly or implicitly, what then? Is that a valid offer? That's the question. Is that a valid offer? the validity, you know that already, Article 4 says that, the validity of a contract, the validity of a clause, that depends from what the domestic law, applicable according to private international law, says. No, some domestic laws, France, for instance, also Belgian law, says, well, a contract without price mentioned, implicit or explicit, is not valid, is invalid. In other words, an open price that's left open in the contract, it's left open. What the price will be is left open. Well, the contract is not valid, according to that domestic law. But other countries, a lot of other countries, are not of that opinion. And Article 55 of the Vienna Convention is not of that opinion neither. It obviously, without saying it, it says implicitly that the contract with no, well, let's say with an open price, will be valid. And then the price will be filled in, the gap will be filled in by the price which is generally charged in the trade concerned, for instance, the maize trade or the wool trade, in the trade concerned at the moment of the conclusion of the contract, at the moment that the contract was signed, contract of sales, contract in which the price was opened. But at that moment, what was the price generally charged in our branch? That's what Article 55 says. Now, in theory, you have here a difficult theoretical problem, because Article 55 is in contradiction with Article of the article of the Vienna Convention about the definiteness of the price. There's a contradiction. The price will be definite, and Article 55, if it's not definite, well, then we fill the gap in like that. So that's contradictory. So in theory, it's really a problem. In practice, not. In practice, it's no problem. Reason is that mostly parties, of course, will in their contract negotiate and mention the contract. In the majority of cases, it's like that. And also, more and more countries accept the possibility, contrary to France, for instance, the possibility that a contract can be open, but it must be possible to fill it in later. In practice, as it's filled in later, that will be okay. So this problem is not a real problem. I would say it's only a problem for professors. Well, ladies and gentlemen, I think that's enough for today. And we see each other tomorrow. I wish you a very good rest of the day.
Thanks for your class.